Though he has applied for by annexure to
Certified copy of what?
the orders, my lord, mentioned in annexure 2, 3, and 4, my lord. Those they have given the slip till date they have not supplied, my lord.
Are they originals?
My lord.
Are they originals?
Yes. No, orders of the court, my lord.
Orders of the court. Why orders of the court are not given?
But I have to take instruction of the matter relates to 2001, 2002, my lord.
No, if they are available, orders are preserved eternally. Readings are not.
Lordship.
Huh?
I'll take it.
Currently, DSC is requested to accept notice for so matter lies in a narrow compass. Which court should give?
That is not specifically.
One is the ADJ court, others are the revenue court, my lord.
Orders of revenue court.
Yes, ma'am.
You take a decision, if they are available, give them. The short grievance of the petitioner is that the certified copies of certain orders made by revenue courts have not been given despite applying. First, learned ASC, Mr. Ray, appearing for the OP, submits that he would instruct the jurisdictional official to issue certified copies if original records are available. First, this is fair. Next point is inspection is disposed of. Time for compliance is 2 weeks. Okay.
Item 2.
Next.
My lord, matter relating to mutual interdistrict transfer. The present petitioner has made application along with OP number 6 for mutual transfer, and both the application of the petitioner and opposite party number 6 have been duly approved by the respective DOs.
OP number, the petitioner and OP number 6 had sought for mutual transfer, which has been recommended by OP number
Respective DOs.
OP.
Both
3 and 4.
3 and 4, madam.
OP number 3 and 4. Who happen to be the jurisdictional officials in this regard. First one, counsel for the petitioner complains that despite all this, no decision is being taken by
Directly.
OP number 2.
Madam.
OP number 2, and therefore he should be mandamus. Next paragraph. Learned ASC appearing for the OPs.
Except 6, my lord. For all the OP except 6.
6 private open.
OP numbers 1 to 5 and notice to OP number 6 having been dispensed with, very fairly submits that he would instruct OP number 2 to look into the grievance of the petitioner in the light of alleged mutual request for transfer in a time bound way. First, he puts a caveat that all contentions of the party should be kept open. All contentions should be kept open. First, with this proposal, counsel for the petitioner confirms. Next, 2 weeks. Within 2 weeks, you have to. Yes.
Item 3.
Now, no court. It will be viewed very seriously. Open to solicit. Next.
Item 3.
Please, your lordship. This is a revenue matter. This is a revenue matter. Kindly transferred to assignment bench.
Registry to verify the fact matrix of the proceedings and post it before the roster bench. As requested by the for the petition. Next.
Item 4.
May I please, for item number 4,
Yes.
kindly, my lords, kindly at the annexer 10, page number 45. Annexer 10, page number 45. Paragraph number 7. In view of the aforesaid development, this court is of the view that the order dated 28/11/2023 has been duly complied with. While dropping of the present contempt application, liberty is granted to the petitioner to challenge the order dated at May 2024. Hence, the petitioner filed this read application.
You are from which place?
I am.
Yes.
I am Denkanal.
Okay, issue notice.
My lord, instruction to appear for OP1 Union of India.
Three.
Ajay Kumar, senior
Appears for OP number 1. Then the DSC appears for 2 and 3. 2 and
2, 6.
2, 3 and 6.
And 6 is state.
Emergency 4 and 5.
My lords, OP4 and 5 will be represented by Advocate Tarakanto Patnaik for NIOS.
4 and 5.
4 and 5, Advocate Tarakanto Patnaik.
In addition to taking legal steps, it is open to the petitioner to serve a copy of the petition along with all the documents for on the panel counsels with Patnaik.
Advocate Tarakanto Patnaik.
Appearing for 4 and 5. First time. Okay.
Item 5.
Obliged.
Related to grant of RSCP to primary school teacher, my lord, covered by Saraswati.
Yeah. You take decision in manner. All conditions are kept. I love that there. You have not changed
Only 3 cases, my lord, representation has been required to be changed, my lord. That I have given a chart, my lord.
the subject matter of all these petitions is substantially similar to the one in WPC 32152 of 2025 between Sriram WP substantially similar to the case in the state of Odisha and others versus Saraswati Bhui 2022 2 ILR Cuttack 629. First, counsel for the petitioner submits that in the said case, a direction has been issued for considering the similar representations for the grant of grade pay of rupees 4,200 with effect from 1/12/2014 on completion of 20 years of service in a single cadre towards the financial upgradation under RACP scheme. In first application. That's correct. Let counsel ASC, Mr. Sen, appearing for the OPs, very fairly agrees that the subject representation should meet their fate at the hands of OP number
1, my lord.
OP number 1. In the light of observations in Saraswati Bhui Supra.
Only WPC number 33284 of 2025. That is with effect from 30/11/2018.
Last date of it, na? One date or any respective date.
Item 6.
May I please, my lords? Senior lords, I am a regular ministerial staff of aided education institution and now serving as junior clerk, lords. Here I challenge the show cause notice issued in a departmental proceeding by the Annex 1, page 16, lords, by which, lords, a show cause notice was issued, a handwritten show cause notice was issued without an office order number by the director of opposite party 2, lords. And in the show cause
reply to this.
I gave reply on the same day.
Saying?
On the same day.
Saying?
Saying, lords, that the allegation, the charge which is labeled, with regard to impropriety in maintaining financial aspects is not within my control because I am a junior clerk and the charge of handling the financial affairs, lords, had been given to some other person. He is a temporary employee, lords, and he was not on leave. So that's why I was dealing with dual charges And in that course, my lords, so I had not maintained the daily report, my lords. There is no, my lords, charge with regard to, my lords, financial defalcation, my lords. So, my lords, the peculiarity of the show cause, my lords, you find that a handwritten show cause, and not without an office order number.
But you have replied, you have understood it and replied to it.
I am saying, Lord, that show cause notice has been issued, calling upon me to give the reply on the same day within 6 hours. On the duration portion, I had got no option. But because in the event I don't give the reply, some course of action will be taken. So on the same day,
You said
without giving us an opportunity.
what you said in your reply.
Reply, these things I narrated, since the charge.
Where is that reply?
My reply,
Page 22, my lord. Annexure 4.
page 22, Lords. The
One
second.
second.
My lord.
You have admitted the charge virtually.
Yes, I have admitted saying that the second paragraph. May I read, Lords?
Yes.
Therefore, due to lack of time, I am unable to maintain the cash book and other bank details. Again, I am to include that the daily assistant who was managing the DCR, the daily
He was on leave.
yes, not coming to the college for the last 6 months, as he was not getting salary from the college for his irregular appointment made by the ex principal. Therefore, I requested
Granting 2 more weeks for regularizing the account.
now, Lords, dismissing the charge and taking into consideration the so-called Lords, the punishment order has been passed.
What is the punishment?
The punishment, Lords, 3 consecutive increments have been stopped, Lords.
You take notice. 3 is on the higher side.
Lord, during
This 3 generally cannot be done unless loss is occasioned. Only the lapse is there. He said he has given some explanation. You accept notice.
That another Lords.
What another? I am issuing notice there.
Jurisdictional ground, Lords.
Emergent notice. They requested to accept notice for OP numbers 1, 3, 1, 2, 1, 3,
1, 2, and 3, my lord.
1, 2, 3.
Lordship.
1, 2, 3. Emergent notice to 4. See, short point is in one. Post it in the second week of January. Okay.
Item 7. May I please also?
Yeah.
Here, the petitioner challenges the order on Annexure 3 granting a death certificate, imaginary death certificate in my name, alleging that I am dead since 18/10/1980.
And you are alive.
Because my nickname was someone else.
Take notice.
I have prayed for stay, my lord.
ASC is requested to accept notice for
1 and 2, my lord.
1 and 2, emergent notice to 3. You appear for 3.
No, he is with me, right?
It's number 3. Let the counsel for the applicants draws attention of the court to application IA number so and so, supported by the affidavit, specifically contending that the person is still alive, and despite that, a death certificate has been issued, which will have many implications. First, matter requires deeper consideration, and the case is made out for issuance of reprieve for stopping the above circumstances. I having been allowed.
My lord,
There shall be stay of
Operation Annexure 3. Annexure 3.
impugned order at Annexure 3. Since this order is issued ex parte, it is open to the other side to seek its variation or rescinding on showing the cause. Okay.
My lord, may I pray one thing, my lord? Now, in pursuance to the Central Act, with the approval of the central government, rule is framed by the state, my lord.
Anyway, there.
No, my lord, one thing, only one thing.
Notice has to we have given you entry order.
No, my lord, no, on one thing, my lord, they have to take instruction on that point, whether the rule was placed before the
It is
state.
for them to take. You can't instruct them as to how they should argue, how they should frame the objection statement. How can you dictate? They know how to conduct their case. Yes, fine. Item 8.
Well, case of the second round litigation, the claim has been rejected by the union government. That is why I am before my lord. This is case of
Pension.
no, my lord, that service up to 65 years. Because I am forced to retire at the age of 62, though I am a teaching faculty. I am a physical training instructor.
To 65.
I am to continue because as a teaching faculty, I am to continue up to 65 years.
Under UGC.
Under the NITs, my lord. This NIT at Rourkela was on the erstwhile REC, Regional Engineering College. It was there. Thereafter taken over by the central government by NIT Act 2007. In our under old rule, I was appointed where that state rule 26 clearly provides that I am a teaching staff, academic staff. That is why I am to get all the benefits of a teaching faculty. The central government, after enactment of the NIT Act, they have also added that your service condition will not alter. So I am to continue as a teaching staff.
Where is that central government literature?
My lord, kindly see, I have put both the rules in the page 6 of the brief.
No, which
Section
act is of 2000? Which is that act?
NIT Act 2007.
Whether it saves the existing
Yes.
condition. That is the section.
I have 5D. I put it.
Where?
Kindly see, my lord, page 6 of the brief. First, kindly see, my lord, the REC rule. Thereafter, I have put it in same page.
26.
6, only 6, my lord.
No,
read petition.
Rule 26.
Rule 26. Academic staff means
Staff of the college.
teaching staff, including principal,
College, department, professor,
physical training instructor.
So. You
I'm
fit
physical
into that
instructor.
definition.
Physical
All right.
training instructor. Yes.
Answer the question.
5D. Small matter.
question.
Yes.
Yeah. Whether you fit into this definition.
Yes.
Therefore, you are a member of academic staff.
Yes. I'm physical instructor.
Where it is stated that you will retire at the age of 65.
No, that was I am physical training instructor. When it was
for academic staff.
that is academic staff. If you kindly come to 5D. This is NIT Act. Towards bottom mirror. I have put it. Next page is 5D. Every employee, person employed.
The 65.
65 is a government notification subsequently by the, because initially it was 58, kindly turn to page 23 of the brief. The government of India has issued the notification.
23.
Page 23, annexure 3.
Go to 22.
The age of superannuation towards last
We are holding teaching positions.
regular government.
Regular and post as on 15/3/2000. In
62 to 65.
centrally funded higher and technical education under the ministry shall be increased from present 62 years to
65
years. Shall be increased.
Yes.
Who should increase?
The Board of Governors has passed the resolution.
Where is that? Show that.
No, so there is a committee, Sancheti committee report. Sorry, I said a wrong thing. Not the Board of Governors. There was a committee constituted for this purpose. This is a voluminous one. I have it. I have not filed it. It was in the earlier petition.
Show the resolution whereby the age of retirement is enhanced from 62 to 65. Pursuant to this direction. This direction as such does not increase.
Yes.
It directs the concerned authority to increase.
Yes.
Where is
That is why all the NITs I have given only one.
No, I do not know. You show that.
Then I have to give it the complete document. That is a voluminous one. That is why I have not filed it. But I have filed it. Can you see one document at least?
That is the very important, crucial.
Yes, I know it. But because it's a voluminous document, I have stated it. I have not filed.
Where have you stated? Where is the resolution of the board?
I have not filed it.
No, you have not stated it also in the pleadings. Board has taken the decision to increase accordingly. Where is that? You have not taken that pleading at all.
I have stated Sancheti committee report. I have stated so.
Committee report is, there will be many committee reports.
That is the only committee constituted by the government of India, and that has been accepted by all the NITs.
Where is the acceptance?
I have given only one document so far. The NIT Warangal and other document, they have taken kindly page 31. And it's a 5, 6.
is not Warangal.
No, I'm all the NITs governed under this government
Same.
opinion. Same, man. Kindly see one document I have given. This is Hamirpur. Page 31.
No, why not? You have given your institution.
I am the only person, my lord, particularly get the other person. I am the only person continuing since REC structure. Now I am
No,
62.
that's all right. You have
They have not
produced,
given the benefit.
Hamirpur, this, that, etc.
Those
Why not
was-
your institution?
My institution, I am the person I have been continuing since REC.
Correct.
In 2024 only I got at the age of 62 years. When they have given a notice to you go and retired at the age of 62, I came before this honorable court. This honorable court taking note of all these things directed the central government to take a decision on this issue.
You produce that document to show to me
Yes, ma'am. This is what that Hamirpur,
next week.
they have extended.
Yeah.
Item 9.
That's my submission.
What?
I am.
I-
I have not issued any notice to you.
Yes.
May I please, your words? My lord, here in this case, my lord, 200 students are prosecuting study in our school, my lord. And what happened, my lords, in the year 1984, my lords, 23 decimals of land, my lord, which was purchased by the institution from the father of the present, my lord, the private opposite party, my lords. Then in the year 1989, what happened, my lord, the land was converted to in the name of the...
Where is your grievance petition?
My lord, under Annexure 1, man. Under Annexure 1, your lordship may kindly see page 12, my lords. And this grievance petition was before your before the learned collector, my lord.
What is the grievance?
Grievance is that, my lord, the private opposite party and some person supporter, my lords, they are coming to the schools while the school is running on, my lords, and creating this type. On this strength that, my lords, that the land was recorded in the name of their father, my lord. In fact, my lord, the land in question that was sold to the, my lord, the institution in the year 1984, my lords. And I have annexed the, my lord, the salary also. And the lacuna was there, my lord, that it was not...
Take a call on that representation. Second. Petition needs as under. Go to prayer. It refers to a representation in the vernacular dated 23/6/2025 at Annexure 1. First term. Learned counsel for the petitioner submits that justice should be met to his clients. Client or clients? Clients. If a direction is issued for consideration of the subject representation in accordance with law and in a time-bound way. First term. Learned ASC appearing for the answering OPs, official OPs, submits that he would instruct OP number 3. OP number 3, collector, to look into the grievance of the petitioner after giving an opportunity of hearing to all the stakeholders. First up, he puts a caveat that all contention should be kept open and a reasonable period be granted. First up, this is fair. Next one, in the above circumstances, petition is disposed of, giving the 8 weeks. No, 4 weeks. 1 week. You take a decision in 4 weeks. Why they should come there and disturb them? 4 weeks. Okay, all contentions kept open to solicit, but our registry to send copy of this order by speed post to all private parties to whom notice is dispensed with. Okay.
May I pay another thing, my lord? Because the examination is on ahead, my lord. Now, my lord, the students are suffering. Till a decision being taken by the OP number 3, nobody should enter to the premises of the institution, my lord.
No.
Because the examination is on ahead, my lord.
Next.
Item 10.
May I please, your lordship?
Yeah.
Petitioner appeared in the interview pursuant to the advertisement dated 8/1/2024, that is under Annexure 2, your lordship. 194 post was advertised for the post of Hindi teacher. Petitioner stood successful throughout the selection process, even participated in the document verification process.
Issue notice. ASC is requested to accept notice for
1 and 2, man. 1 and 2.
1 and 2.
1 and 2. How much
Yes,
is
your lordship.
notice to 3?
Grateful, your lordship.
Item 11.
May I please, madam? The husband of the petitioner was a primary school teacher, my lord, appointed under the reputation assistant scheme. Because he was in survey, he was not trained, so he was sent for training.
Where is
as
your representation?
representation Annexure 3, my lord.
short grievance of the petitioner is as to non-consideration of his representation dated 4/11/2023, wherein he has sought for releasing of the arrears of salary for a particular period.
Salary concerning the husband of the petitioner.
Salary relating to, no, husband is not there.
No, yes, ma'am. Yeah, that's
Relating to the deceased husband. First, the counsel for the petitioner submits that if a direction is given to take a call of the subject representation, the client would be happy. Next paragraph. The AGA, Mr. Lanka, on request accepting notice for the OPs, although initially opposed the petition, now agrees to instruct the OP number.
OP number 4, madam. The district education 3, madam.
OP number 3 to look into the grievance of the petitioners, provided that the court keeps open all contentions and gives a reasonable period for consideration. First one. With this proposal, counsel for the petitioner posits. Next one. 8 weeks. Open to solicit. Right. So, item 12. Next.
This is the matter relating to sanction of increment, my lord. Since 2020.
7924 is your representation.
No, my lord. In that representation, I have pledged to supply the documents. Departmental proceeding was initiated. Thereafter, petitioner filed a representation for supply of the documents on what basis the proceeding has been initiated, my lord. They did not supply, and on the basis of proceeding is pending, they did not sanction the increment since 2020.
How can you withhold when pendency of the disciplinary proceeding? Withholding of increment can be by way of punishment.
Well,
not on pendency of criminal proceeding or disciplinary proceeding.
Let him file a representation, then.
It will not help anything. Or you want to file a representation?
my lord. Press representative, that may rule 77 as per rules that may be considered.
The petitioner, please be seated. Petitioner seeks a direction to the OPs to sanction and grant increment that have accrued due with effect from 15/11/2023 under rule
77, my lord.
77.
7 of Odisha Service Code.
Rule 77 of Orissa Service Code. Service Code. First, the counsel vehemently argues that during the pendency of criminal proceedings or disciplinary proceedings, the accrual of increments is not halted, and therefore the accruing increments have to be accorded to every employee. First number. Next paragraph. Learned AGA, on request accepting notice for the OPs, submits that the petition is not preceded by a demand and rejection, and therefore petitioner cannot be granted any relief. First, at this stage, counsel for the petitioner submits that her client would make a representation to OP number.
OP number 2, my lord.
OP number 2, district education officer, and if a direction is given to consider the same in a time-bound way, justice should be met to him or her. Her. First up, this is fair. Next one, in the above circumstances, petition is disposed of, granting liberty to the petitioner to make an appropriate representation within 3 weeks, and if one is made, OP number 2 shall take a call thereon within 3 weeks next following. First, all contentions are kept open. Delay shall be viewed seriously. Open to solicit information. Next.
May I submit, my lord?
Yeah.
That my representation may be considered under Rule 77 of Odisha Service.
77
of Odisha Service.
Okay. Obliged. Item 13. Yeah.
May I please, ma'am? This is
Suppose if I say Rule 77, but some other rule is applicable, then what should happen? Or such other relevant rule.
In accordance with.
Or such other relevant rule.
In accordance with law.
The law will be too wide. Much of law will not be known to them at all. Yes. Next. Item 13.
May I please, ma'am?
Yes. Take notice. Attachment is there, na? Mr. Issue number 10 notice, Mr. Entirely requested to
1, 2.
notice for 1 and 2. 2 emergent notice to 3, 4, 5.
Item 14.
May I please, Lordship? Lordship, this is the matter of RSP covered by Ashok Mahapatra. Your Lordship has passed earlier.
You have to give copy to your senior friend.
Lordship.
Otherwise, I'll put it. Get the Xerox and give it. Yes.
Item 15.
Pardon for item of 13. Office for 4 and 5, but there is the council there. They are just Mr. Venugopal Mahapatra. I will take notice.
Soft copy will be served. Allow me. Sorry.
Item 14. 15. Item 15.
Included only CBSE, and there are 2 opposite parties, only that part.
One and two.
1 and 2.
Instead of 3, 1 and 10.
Obliged.
Yes. Follow.
Item 16.
May I please? Petitioner is the purchaser of the plot from the BDA authorities, my lord, and after purchase the plot has been handed over to the present petitioner, my lord, and he is in position.
Consent deed is not executed.
Not your lordship.
Who should execute?
BDA, my lord.
BDA.
BDA, my lord.
Who appears for BDA?
Mr. Mahapatra, the senior advocate, is associate in the
The consideration of your representation in accordance with law, send that copy by speed post to them.
Yes, my lord.
Okay. The contentions I will keep open.
Yes, my lord. As per the decision of this honorable court, I have mentioned.
Your annexer 9 to be looked into, na?
Yes, ma'am. Line 2 on the basis of the judgment under annexer 11, page 55, the representative will be disposed of. This honorable court has already passed this judgment, my lord.
Annexer?
Annexer 11, my lord.
Which is that WPC, annexer 11?
Yes, 180, 169, 223, Jyoti Prakash Mishra. Yes.
The short grievance of the petitioner is as to non-consideration of his representation at the hands of the BDA, who has to execute and register the lease cum sale deed post the allotment of the subject site.
Pre-possession.
And the new possession as well. Learned counsel for the petitioner submits that this representation is liable to be considered in the light of the decision at the next part. Learned AGA Mr. Behura request appearing for OP number 1 submits that the decision has to be taken by OP number 2. First, since the petitioner is the prayer of the petitioner is innocuous in the sense that he prays for an order to pass an order on the subject representation, notice to OP number 2 is dispensed. First, next part. No prejudice will be caused to the other side if a direction is issued to consider the subject representation, keeping in view the law and also the ruling, a copy of which is the ruling supra. First, next one, in the above circumstances, petition is disposed of granting a period of 8 weeks. Right. So open to solicit now no cost. Registry to send a copy of this order and speed post to OP number 2 immediately. Next, all conditions kept open. Next.
Item 17.
On behalf of Mr. Del Rai, my lord, may I please? My lord, the petitioner's grievance is that while she was continuing as a guest faculty and the contract was there, another advertisement was issued, and though this matter is already has been decided by this honorable court in other matters.
What way it is decided? that they should be continued.
Yes, madam.
Where is that? You copy to your friend also.
Yes, madam.
University matter.
Yes, my lord. Dharandara University at Cambridge.
Matter is still pending.
No, it has been disposed of, madam.
Issue emergent notice. Any counsel is there for the university? You take notice.
The matter is pending.
Pending.
Matter is pending.
Yes.
One side director.
AGM Mr. Behra is requested to accept notice for 1, emergent notice to 2. Any IA filed?
Yes, my lord.
Petitioner has moved an application in IA number so and so supported by an affidavit on the apprehension that his services may be dispensed on the ground of contemplated recruitment process. And therefore the same should be published. First off, he also tells that the job at hand is the only source of livelihood. And therefore, decision of Apex Court in Olga Tellis versus Bombay Municipal Corporation, AR 1986 SC 180 is applicable. First, there is court submission and matter requires deeper consideration. Next, in the above circumstances, application having been favored, a direction issues to OP number 12 continuing the petitioner in service until further order subject to same terms and conditions. First off, since this order is issued next paragraph. Since this order is issued ex parte, it is open to OP number 2 to seek vacation or modification of the said order. The grounds do exist therefore. Yes. Item 18.
Yes, sir. Very innocuous prayer has been made.
91 of Orissa Development Act.
Yes, madam.
Any violation of the bylaws?
Yes, madam. By the opposite party number 4, though that application.
You take notice. Take notice.
May I pray, your lordship direct the OP number 4 to consider my application, because I have said that the other side be noticed and the so cause may be issued.
And the 4 is the private party.
Private party. Well, it will be decided by the BD authorities.
Who should mediate?
Yes, OP number 3, ma'am.
Petition prayer reads as under. Counsel for the petitioner submits that his client has given a representation dated
2, ma'am.
Has given representation dated?
That is dated 15/11/2025.
15/11/2025. A copy whereof avails at Annexure Q.
Annexure 6.
Annexure 6.
What is this? Yes. Annexure 6. Wherein we are sought for initiation of certain coercive proceedings against OP number 4 for putting up construction in violation of the bylaws. First, he submits that if a direction is issued to pass an order on the subject representation, justice would be met to his claim. First, next paragraph. Learned DAC appearing for the OP number 1 on request submits that the decision has to be taken by OP number 2 in the light of section 91 of
Odisha Development Authority Act
1982. 1982. First on. Next paragraph. Learned counsel for the petitioner submits and discourse agrees that the notice to OP for other OPs can be dispensed with, since no coercive order is being passed by this court, in as much as it is only in as much as the prayer is only to pass an order on the subject representation, keeping open all contentions of the party. First off. Next one, in the above circumstances, petition is disposed of, directing OP number 2 to consider petitioner subject representation dated 15/11/2025 within a period of 6 weeks. 6 weeks. After hearing, giving an opportunity of hearing to all the stakeholders, including the petitioner hearing. First, all contentions are kept open. Next paragraph. Since this order is made ex parte, OP numbers 2, 3, 4, comma, it is open to them to seek its modification or recall if grounds do exist therefore. First term. Registry to send copy of this order to OP numbers 2, 3, 4 immediately by speed post. Okay.
Item 19 has been added. Then item 20.
May I pronounce? In this case, petition challenging the order dated 8/10/2025 issued by the CBSE for cancelling the result of the petitioner on the ground that he has found indulged in unfair means. Similar matter, my lord, your lordship issue notice.
Same order. Any examination is being taken? No.
No, man.
Follow on. Next.
Item 21.
Yes.
Whenever we have filed this application, actually no one is there.
No, you have not implemented the order.
That is, reprehension is to be disposed of.
No.
In this specific
That is
order
not been
dated
done.
12/8,
Yes, that has not been done. Issue police
May I take instruction? This is first time.
First time, correct. But where they are all private parties, no? Take a shoot. Go to the cost statement.
They are, no, single.
Issue emergency notice, Mr. Montiel and AG accepts notice for all the OPs.
Hello, sole stage.
Since complaint is as to non-implementation of the writ of this court, call this matter week after next. Yes, for taking suitable action against the erring officials.
Item 20.
I will take notice.
Yes.
My lord, this is a fresh content, my lord, on non-compliance of the order dated 4/8/2025. My lord,
Who are the parties?
My lord, university. Yes, my lord. My lord,
Same order.
Item number 17, the DD University. This is also DD University, my lord. Dharna University.
One is Mohanty, na?
No,
1 and 2.
1 and 2, yes, my lord.
They have not served copy of us. They are against the DD. They are the autonomous university.
University, sir.
They have their own panel.
Own panel.
No, for 1 and 2 you are appearing. Odisha, state of Odisha and director of higher education.
No, my lord, item number 20.
Contempt we are not there. This is Sundar Patnaik. BC come OSD DD University.
Yes, 22. Yes, my lord, 22.
Which one you are showing, brother? 22.
Item 22.
State of Odisha is there.
No,
my lord.
This is Narayan Chandra Samal.
Professor
21 or 22?
22, my lord.
22. Narayana Chandra Samal.
Yes.
Take it.
21 completed, my lord.
Yes, it is completed, na?
Yes.
In 22, who are the parties?
My lord,
The only parties so far the cost title is concerned, Professor Samsundar Patnaik, the VC.
VC, Vice Chancellor.
OSD DD University.
Kindly see your papers.
Contempt.
Which case you have brought to the court? Maybe different case.
My lord, 22, my lord. I have 22.
22.
Yes.
Okay, you are right. Which one you are showing to me?
Sir.
Yes. No, you are right. Our issue emergent notice.
My lord, already the Honorable Court, as per the Honorable Court direction, they issue notice me.
It has to go.
Yes, my lord. They also issue notice to me to hearing the matter. Also concluded a hearing, but not publish any result.
Therefore, we have to issue notice.
My lord, it is a
No
guest
notice will be
faculty.
issued.
No, my lord, it is a guest faculty teacher, my lord.
Issue police notice to OP numbers 1 and 2. Returnable within 10 days. Yes, next.
Item 23.
Item 23, my lord, I am on VC, my lord. Prayer for anticipation of regularization, similar matter, my lord, have already disposed of. I have supplied the copy. My friend is there. He is supplying the copy. I have already supplied to government, my lord.
You bet.
I'm up to the presentation annex of 10, my lord.
Same prayer.
My lord, same per annexure 10, my lord, is to be taken into consideration in view of the decided by the High Court, this Hon'Ble Court as the Appeals Court.
You rectify this, you give rectify copy. You serve copy, otherwise you will not pass out a call after in the January.
No, my lord, sorry, my lord.
Why are you not serving copies on the government advocates? How they should defend that? They will not be knowing anything at all.
No, sorry, ma'am. Wrongly, I have submitted both copies.
Rectify the other things. This board one.
And the tagged matter, my lord. Tag, my lord, I have already similar matter issued notice, my lord. I have given the number, my lord. The number last Monday, I issued notice.
What should be done in that?
Notice was issued, my lord.
Notice has to be issued.
Yeah, in identity to was issued notice. WPC
28906 of 25. Issue notice. EGA request to accept notice.
All states.
Call along with the
WPC 2189 of 2025.
Give that.
Item 24. May I please, Your Lordship?
Yes.
This matter related to the demolition of houses, which was before Your Lordship yesterday, in item number 28.
Same order.
Yesterday recaptured. There are no such specific order so far the demolition.
Therefore, we told them, before taking any action, you do all this. Same order.
By that process, it has been disposed of. One matter was left out. Possible that matter.
And then some papers are missing. Page 10 to 12, item 24. Just not served.
The annexes.
Annexes are not served on you. Why you have not served?
This is served, but some papers are missing in the petition.
That a complete copy be served by that.
No copy is served.
My lord, nowadays we are not solving the copy. It is automatically solved.
Two papers are missing.
It is scanning and
The petition.
Yes.
Which
Page 10 to 12.
No, here, they are here. 10, 11, 12.
But he has solved the copy.
I am not solving. It is automatic, sir. It is automatically solved.
Let
I will solve another one, but we are not solving nowadays. It is automatic, sir.
E-filing.
Yes.
The subject matter of this petition is substantially similar to the one in WP number. They made that there is not.
Serial number 28, double petition number 31754 of 2025.
Disposed of between so and so, disposed of by this court by granting some reprieve with some observations. First one. Next one, that consent for the petitioner submit that the similar relief needs to be granted to his client, who is similarly circumstanced on the principle of parity and equality as held by the apex court in a category of decisions. First one. There is force in this submission. Next paragraph. In the above circumstances, petition is disposed of with the served terms and conditions, granting same relief as has been granted in the cognate case. Mutatis mutandis. Okay.
Item 25.
This case has already become infructuous, my lords.
Counsel for the petitioner, sir. All these,
My lord.
all the 3, 4.
My lords.
So that counsel for the petitioner submits in all fairness that these petitions be disposed of as having become infructuous. Preserving liberty.
My lord.
But no, first. Ordered accordingly and petitions are disposed of. Yes.
Item 26 has been added. Then item 27.
My lords, item 27 is request instruction why final pension is not granted.
My lord,
I will take instruction 2 weeks time. Maybe.
so far as item 27 is concerned, my lord, previously notice was issued and there is an admission that there is no legal impediment. After 7 years of retirement, a person is not getting his retirement dues.
You will get
my representation
interest also.
Representation.
Your representation is 18,424.
24.
If that is considered well and good,
let it be considered, my lord.
will it happen? Will justice be done to them? To her?
They will assign any reasons if.
But the grievance of the petitioner is reflected in the prayer column. First, counsel for the petitioner draws attention of the court to his client's representation dated 18/4/2024, wherein he has sought for sanctioning and disbursement of terminal benefits such as pension, gratuity, committed value of pension, etc. First of all, counsel complains that though the retirement took place on 31/5/2018, with no justification whatsoever, the terminal benefits are not accorded, and therefore matter should be treated very seriously. First, next one. Learned AGA appearing for the OPs very fairly submits that he would instruct the jurisdictional authorities to look into the grievance of the petitioner as has been aired in the subject representation on a war footing, and let the petitioner know of the result of such consideration. First, he submits that the petitioner should also cooperate with the authorities if any documents or records are needed from his or her side, his side. First, counsel for the petitioner agrees with this proposal. Next one. Within 6 weeks. 6 weeks. Open to solicit. All contentions kept open. Delay will be viewed very seriously, and thousands of rupees cost may be levied on the hearing officials if an application is moved by the petitioner.
Item 29.
Covered by your judgment, madam. MP similar, madam. The prayer of the petitioner has preferred appeal, and appeal has already been rejected, madam.
Rejected.
MLP. Madam.
Where is that show? In every case, there is MLP. Mr. Manti, just look into whether or not on that.
Kindly see page 44, madam. Transfer order.
Order itself says.
Madam. The order also itself and the rejection order also said the MP madam.
The subject matter of this petition, these petitions, is substantially similar to the one in WP number.
Sorry, 1 minute.
So between so disposed of by this court. By order dated yesterday.
WPC number 2087 of
2085, madam.
2087 of 2025. Ranjan Kumar Tripathi.
Relief has been granted to the petitioner, the litigants of the kind, by setting aside the transfer orders. Of course, subject to certain reservations made in paragraph 4.7 of the judgment. First, next, in the above circumstances, all these petitions are also disposed of, granting the same relief with the same reservations. No costs.
That is on 27/11. Judgment dated 27/11.
27/11.
In actual 11 may be cost matter or appellate order.
First of all, the impugned orders are quashed.
Transfer order as well as the appellate court.
Impugned orders are quashed. Okay.
Item 30.
All contain all matters same.
Petitioner shall be restored to the original positions, subject to what has been observed in paragraph 4.7 of the cognate judgment. Okay. 30.
May I please, Your Lordship? In this matter, Your Lordship, the petitioner prays that she should be allowed to give the back paper exam. Your Lordship, in 2019, the petitioner was admitted to Maharshi Women's College. In 2023, her course was completed. After the completion of the course, she...
Notice.
I have taken notice. What the problem
is already?
Yes.
Post notice.
No, Lordship. The alleged exam of back paper is on 6th. My prayer is that she should be allowed, and the result of such examination shall be given effect subject to the result of this petition. Otherwise, she will...
running. Huh? You came running?
Yes, Your Lordship. From 24 to directly...
Who is your opponent?
Yeah, my lord, at the Women's College, this is an autonomous body. It has been declared as a university.
Now it is a deemed university. Therefore, Article 12 is applicable.
Yes. Ujjambai.
Yes.
But at the same time, they are the panel.
They have panel
So because
advocates.
1 to 4 all belongs to them. No way it is state is concerned. Maybe Article 12 retainment,
but they should appear.
Exactly.
My humble submission is, Lordship, on 6th, the examination will commence. I may be allowed to give the examination.
Which examination?
Back paper examination. Otherwise, even if...
Take down. Issue emergent notice. First.
1 to 4.
1 to 4.
Lordship,
Wait.
Okay, sir, Lordship.
Mr. Monti, you should train them. Yes.
Actually, newcomer, I have also considered.
The counsel for the petitioner draws attention of the court to IA number, application in IA number signed, so supported by affidavit. His examinations are, the back paper examinations are scheduled with effect from 6/12/2025.
Yes.
And he has all chances of success in this legal battle. And therefore, he is going to be permitted to take up the subject examination. The examination, subject to outcome of the petition. First, he very fairly submits that. Come on. The result of the examination may not be announced. Also. First, next one. Matter requires deeper consideration. And a case is made out for granting reprieve. First, in the above circumstances, application having been favored. Which OP?
OP number 1 may be deleted, Lordship, because the principal concern is...
Who should be directed?
The principal and opposite party number 2 to
2 and 3.
2 OP numbers 2, 3 and 4.
Yeah.
2, 3, 4 are directed to permit the petitioner to write back paper examination in
which is scheduled to be held that date may be
in which
commencing from 6th.
Which subject which in the concerned subjects 6th subject to outcome of the petition. First, however, results need not be announced. First, petitioner shall not plead any equity on the basis of the interim order. First, registry to send a copy of this order to OP numbers, to all the OPs for acting upon. First, if interim order is not acted upon, the OPs may be held up for contempt and their defense may be struck off also. Okay. Over. Yes. Wish you all the best. Enjoy and come back.
From the bar also.
Thank you so much.
All hail and hearty in the coming.
Thank you. Thank you so much.
By the grace of Lord Jagannath.
Yes. Yes.
Okay.
Yeah. Item 1.
Item 5. What's item number 5?
So, any adjournments?
Yes. Your Lordship, my
5 will be when this bench will function next.
My lord, item number 6.
Adjournment?
No, I asked for a prayer that the WPC number.
Sir, if you are additional weight, sir, you have to take up one, sir. You can jump the list. If you are adjournment, sir.
Yeah, that's an adjournment.
So take it next.
No. Sir, one request. WPC number OA 445 of 2018. That may be called for and tagged to the W.
Without order, that cannot happen, sir. You have to wait there. Either you adjourn it and on the next date, whatever order will be passed or the.
No, I'll wait.
Yes. Yeah.
May I pray to take it up next week?
Next date, sir. Next week, this is not a bench where we can
I am
fix
not
a date.
feeling well.
Please. So do we need to post it? They will post it, sir. We'll pass orders. The matters will be listed when the bench functions next. This bench.
Item 2.
That you are saying that this is a matter which was not supposed to be tagged.
Yes, madam. This matter relates to work charge employee.
Where is your learned colleague?
They are good.
We'll call it later. Pass over the next matter. 3.
Item 3.
Only notification.
Yes. That's just. But what is modification in absence? Will say another
May I please your lordship?
Mr. Madan, inform the council.
Your lordship, just have a glance to order dated 25/7/2025. Paragraph 7 is the operative portion. Initially, Learned Judge Hon'Ble Court Jadpur had 42 lakhs in favor of the wife. But your lordship, settlement that she agreed on 20 lakhs. Still then now the husband is playing hide and seek. And your lordship.
File execution, sir.
My
You have to file execution.
no, that is execution because your lordship has a past order that 15 lakhs is to be deducted.
I'm sorry.
The next matter going on. Please take your seat.
15 lakhs is to be deducted from the terminal benefit of my husband. And that is order is very clear. That is to be deducted by your lordship will see, that is the competent authority. Now, your lordship direction is required.
So Sajib Mahanti for this is item?
My lord, item 3, your lordship.
Sajib Mahanti for the respondent. You have filed a IE?
My lord, the copy has already been shot.
7 of 2025 has been filed for further direction in the disposed of MATA. Disposed of by order dated so on. The Learned Council refers to paragraph
7, your lordship.
Paragraph 7.
7, 8, and 9.
Paragraph 7, 8, and 9, which I produced herein. It is submitted that despite the direction till date, the Controller General of Defense Accounts has not deducted the amount of rupees 15 lakhs.
My lord.
15 lakhs and credited to the account of the, to be credited to the account of the respondent by.
It is 15 lakhs, your lordship. Later on, that has been corrected.
Yes. 15 lakhs.
My lord. Would like to.
FTW. Copy of the application shall be served on the Learned DSGI, who shall obtain instruction from the appropriate authority by the next date. You serve 2 extra copies.
My lord.
2 extra copies be served. One for his office copy.
My lord.
Forward.
Would like your lordship.
His name to be printed in English. Name of Mr. DSGI, the name of Learned DSGI, Mr. So-and-so, PK Padi, shall be indicated in the cause list as well as the case brief on the next date of listing. The matter shall be listed when this bench functions next. Miss pass over, madam. Item 2.
I belong to Varchaj. I am a Varchaj employee. Kindly say annexure 1 of appointment. That is my lord. For clarification.
So Bharat, if Mr. G agrees with me, if he doesn't agree and say that I'll file affidavit, then that's we have to.
This is the third time that only
Actually, they were not aware.
Yes.
They did not have the brief. We can't take. Yes, Mr. G, so he's saying that he's not covered by this judgment. Have you obtained instruction or have you seen the verified records?
No, my lord. That's it. The return man not getting pension.
Matter has been listed on.
Time and again. Time and again. And man is not getting pension. In Varchaj employee next time so that.
Varchaj employee is listed for 4th of December. Varchaj employee matters are listed directed by the Honorable Apex Court. State versus Sudhanshu Sekar Jain.
No, that is relates to Jesse employee. That is distinction. Sudhanshu Jana related. Yes, Sudhanshu Jana, yes.
Sir, you are carrying full to new question. Both the learned judges are party to the decision of the state versus Krishna Chandra.
Sudhanshu Jana has a lot of mention. Sudhanshu Jana relates to Varchaj employee, Jesse employee.
Sudhanshu Jana has segregated job contract and Varchaj.
Our case belongs to
the judgment. My senior judgment deals with job contract.
Yes, madam.
So that is Krishna Chandra.
My case relates to Varchaj employee.
So that is still pending because Supreme Court has directed to be heard.
No, Supreme Court decide the issue. Varchaj employee they are directed.
Sir, unless you refer to the judgment of Justice Dhulia, are you referring to Justice Dhulia judgment?
I am referring, man, kindly see annexure.
That's the problem.
Annexure 7 kindly see.
Sir, annexure 7 or 8, it has to be Supreme Court judgment.
Yes.
Justice Sudhanshu Dhulia.
No, that my case relates to G. Balakrishna.
So you cite when the matter is taken up G. Balakrishna. Because G. Balakrishna is not the last line on the because the judgment of the Apex Court is very clear. Then the bench was changed and the next bench has already taken up state versus Sudhanshu Jana and this Varchaj is kept is to be heard on 4th of December.
So, 4th of December.
No, this bench will not.
Before
you must understand that after they agree, this matter will be released.
By this process, the problem, by this process,
you are not listening, that's the problem. Many times I have requested you, don't go fast. Your writ petition is now disposed of. It has to be restored by order of this bench or not.
Yes.
So has that happened yet?
I have filed in this case for that.
Exactly.
That action.
He somehow, we don't agree with him. Actually, we don't appreciate also. But what we can do? It is a disposed of matter.
Disposal?
Mr. G.
My lord.
This is a work chart employees case.
Employees case, yes.
So we could not have disposed of.
My lord.
Because that which my brother, esteemed brother referred to, that was not work charged. Because that matter is pending before the Supreme Court. It is not disposed of by this order. There is another matter to which we have referred to. Back to this court.
So lordship separated.
They are separated. One class relates to work charged employees that are kept pending. The other class are disposed of.
Just employee.
Therefore, we can restore this to the original board. It will be held along with other matters.
Yes.
Before the regular bench.
My lord. This can be.
This petition was disposed of by the final order dated 21/11/2020. Correct?
My judgment, sir.
Judgment dated 21/11/2025. On the premise
that is judgment 15/7, my lord.
15/7/20. Along with a batch of matters which essentially related to employees other than work charged. First, counsel for the applicant, who happens to be the petitioner, submits that this matter could not have been disposed of with other matters which are related to non-work charged establishment, since this relates to work charged establishment. First, this proposition is not disputed by learned EGA, Mr. G, after going through the papers. First up. Next paragraph. In the above circumstance, the order dated 25/7
the subject application having been favored, the order dated 25/7/2020.
15/7. Apply to this.
No, we have to recall this one.
No, sir. So what happened, sir?
No, only this, sir. To the extent it relates to this case. Nice, sir. 15/7/2025. To the extent it relates to this petition, is recalled, and as a consequence, the writ petition is restored to the board for being heard on merits. Along with the appeal is restored to the board, along with to be heard on heard along with other connected matters. Question to that's it. It is made clear that the order dated 15/7/2025 relating to rest of the cases would remain intact. Even if
Now this has been followed in 350 cases.
Relating to non-one.
Yes, yes.
Yes, item 4, matter for question.
Last occasion, your lordship directed me to serve a copy ahead, sir. He has also filed the objection to the limitation.
Why before this stage?
Ready to appeal.
No, interpils are not assigned to the special bench.
Honorable Justice M.S. Raman's judgment.
Disabled.
Yeah.
Judgment is of
Raman's judgment. That is true.
Will condone delay.
Delay only
231
days delay.
I have objection that certain part has not been explained. Why?
This really long delay of 200 and how many days?
231 days.
231 days. First time. Appeal is by the state and its officials, correct?
Well,
officials. First time. That application accompanies the application. The affidavit accompanies the application. Application. First time. The perusal of application along with the affidavit would show that there is a plausible explanation for the delay. It's true. First time. Next paragraph. Learned counsel for the OPR respondent. Respondent. Private respondent. Respondent opposes the application contending that enormous delay is not properly explained and therefore it cannot be condoned. First off, we do not subscribe to that view. First off, after all, condonation of delay would not add merits to the main matter to the disadvantage of the opponents. First off, what would happen is the matter would be heard on merits with the participation of both the sides on their respective stand. First off. But next, in the above circumstances, application having been favored, delay is condoned. Okay.
If your lordship can hear it today on merit.
Today we have difficulty,
A small matter.
Saturday. Small matter. For this matter. Next functions.
Item number 5 has been adjourned. Item 6.
May I please, your lordship?
Yes.
In item number 6.
Yes. Connected matter.
Connected record, I back to the WPC number OA 445 of 2018.
That is disposed of?
Yes. That was the first round of litigation by this same petitioner.
Retired prior to 97.
Chandra Mahapatra. The earlier matter is 230 days, not 231. Reported delay of 230. See Mahapatra for the appellant. This was never listed before this bench. Earlier listed, special bench.
No, there is two matters.
No. This particular writ appeal.
Yes.
This has been listed
Before us at any time.
Yes, it was listed.
It was
Your Lordship earlier also.
On 16/10/2025, it was there.
Yeah, not because
the matter has been listed before this bench as per the orders of the Honorable the Chief Justice in the administrative side for listing the matter. For assigning the matter, not listing, for assigning the matter. It is submitted by the learned counsel for the appellant that a connected matter having a bearing on this case has already been disposed of.
Yes.
Disposed in number names.
Number 55. I'm giving them.
WPC number so and so, by whatever number disposed of and so and so.
118.
The records of the said disposed of application shall be disposed of matter shall be placed along with the present matter. Stop. List when the bench functions next.
Can we kindly list it on 5th?
No, we cannot know. We do not know where we will sit.
Because
This is accidental bench.
Sorry. Appearance, Mr. Nikhil, Mr. G.
Mr. Patra.
G for G for 1, 2, 4. Then Sudhir Patra, standing counsel, OP5, accountant general. You have short copies and all, Mr. Patra, Mr. G. What is the
Item 7.
May I please note? Two matters are there, my lord. The matter on earlier occasion, Lordship has sent the matter for mediation. Mediation was not successful. And the another WPC is there, which is connected to this matter. Lordship has taken that WPC on board, wherein the pension account of the petitioner has been freezed by virtue of an application made by the respondent wife. So, Lordship has been pleased to call for the WPC record also.
Which order we called for the WPC records?
Last order, Lordship, mein
Let to take then 3. Any such order?
Yes, order is there, my lord.
In MAT?
Yes, my lord. In
Can we
matter.
kindly refer to that? Just see the paper list. But we are what you see.
Find that. No,
Take it upon just click it.
24/7 is there.
But we are not because
24/7 it is not there.
order up to 4 in my MAT, nowhere it is there.
My lord, that is order dated 36/2025, order number 3. Learned counsel for both the sides agree that the husband's WPC number 5
Take a double and with this.
This is the copy of the order. Perfect.
So we are seeing that, but you are not seeing. No, that is how.
Again.
It is before us, but yes. No, where are the parties?
Other side, not served.
My lord,
Not served.
other side, he was appearing regularly, my lord.
Bring him next time. In his absence, these are all these matters we cannot decide in absentia.
My pension account has been freezed, my lord.
It is very hard to survive. I am a retired railway employee. I'm not getting my.
So what, Mr. Misra, you have the instruction, then what is the total dues? We can direct.
No, but
the deduction.
My lord, 5 lakhs the alimony was granted. And
total dues you are answering.
My lord,
Please answer.
1,87,000 was the arrear maintenance pending, and 5 lakhs was the alimony amount which was paid by which was directed by the learned family judge to be paid to the wife. But the day the judgment was passed, just after 1 day, the wife filed application before the branch manager, and my account has been freezed.
That money she has also not got.
No, my lord. She had taken from my account 15 lakhs, my lord, which has been admitted by her in her evidence.
Again, that order is not there in the learned single, sir. Kindly see the read. Read dekha to order uda. Freezing order is not there. And this is by the wife, not by you. The read is by the wife.
Read is by me. The mata is by the wife.
Is
me, myself, my lord.
Sorry, I misunderstood.
No, because they do not write Srimati, Shri.
Yes, sir.
That culture is not here. They will take everybody as for granted. Where is that order, freezing order?
Mr. Misra,
my lord,
instead of troubling here, you bring at least the counsel for the bank, because you have challenged you have made the bank a party.
That order is that order is available to my lordship at page 86 of the writ petition.
Date of the order?
Date of the order is 11/2/2025.
This is bank's letter.
Yes, to me. The CP order was passed on 7/1/2025. Annexure 5, lordship, may kindly have a glance. Lordship will visualize. Annexure 5, page 84.
Who appears for the bank? Now, whether bank has only complied with the order,
my lord,
or bank has made that order on its own.
My lord, the wife has given the letter which is annexed by me under Annexure 5, my lord. Basing on that letter, the branch manager has freezed the account. I have made a representation to the branch manager under Annexure 5, but he answered at page 86.
Saying
that your account has been freezed on the application made by the wife.
Where is that order of the bank freezing your account? I'm not getting it actually. You refer to page 50, Annexure 2.
86.
Page 86, my lord. The initial application of the wife.
86 is by the bank.
The initial application of the wife is at page 84, my lord, Annexure 5.
Because it's a joint account.
Because it is a joint account. And it is my pension and salary account. Earlier it was my salary account, now it is my pension account. And from that account...
All right, you bring the bank's advocate and we'll do the needful.
And just be sure of the amount that is due.
That is
so now the
5 lakh is the alimony, 1,87,000 is the arrear.
So there is a catch to this. That joint account is either a survivor, farmer or survivor. I think the joint account would be
husband and wife.
Husband and wife, either.
Husband and wife, either a survivor.
Either.
Then, if it is frozen, her account is also frozen. No. It is her account also.
She is maintaining this.
No.
She is not maintaining anything.
Tenon on banking law. Right. When there is a joint account and one of the account holders writes to the bank for non-operation, bank can stop operation of the account.
But it is a salary account of mine, my lord.
Oh, that is your mistake. You should not have put all your eggs into that.
That mistake he has done.
For that mistake, you have to hear the others.
To check the law on that, also, please also consider that it is her account which has been frozen. It is not your case that she is utilizing that account
No, it's
Very
a joint account.
He has withdrawn the money from that account, my lord.
Yes.
Which has been recorded in CP judgment.
Problem is that if it is either or survivor, then no one cannot use the account. If farmer or survivor, then the first holder. If the second or the survivor, then only the second holder.
ସେଟା ଜାଣିଛି ମୁଁ ପିଲାଦିନୁ ବାପା ବ୍ୟାଙ୍କରେ
not either.
why, my lord, without my pension?
Definitely, we will not.
I'm a retired employee. If my pension account has been freezed,
Because you are mistake that you put that pension amount to that, you give that.
that mistake, my lord, I have committed for which this matter at the age of 68. At the age of 68, if my lordship will see the evidence of two son who have reported, my lordship will be surprised. They have given evidence against their mother.
No, you bring the opposite party, so that once for all. And whatever the notice to why?
Yes, the notice has been issued.
Yes, then what happened?
She has appeared, my lord. She has appeared through Mr. Panigrai. Yes, Vaisutta Panigrai. Read also, my lord, it is indicated.
You filed the arsenic. For 3 seconds. My instruction now like someone I think last time.
My lord.
To request party driver to take notice for her wife. Wife is also party to that WP.
Yes.
It's even WP.
Yes.
Yes. In Mata 83 of 2025, filed by petitioner in WBC.
No, my lord. That is, the matter was filed by the wife.
Filed by
OP number 2.
the wife.
Wife.
Filed by the wife. WBC 5999/2025 is filed by the wherein parent along with the wife are parties. First, Mr. Hon'Ble terminated to place for the right to therefore, we request Mr. Hon'Ble to accept notice for wife who happens to be the Supreme in WBC. In as well as number 2. I think nexus between the.
I will also inform.
Petitioner to serve copy of the petition on the Hon'Ble. First, registering to telephonically inform Mr. Hon'Ble to some that. First, for this matter, when the bench mentions. Absence of Mr. Hon'Ble is noted under in Mata.
I pray one thing, my lord. This matter cannot it be listed in the regular bench, my lord?
If you want, let them both, because there is order of Honorable CJ, perhaps.
No. No order is there.
No, we requested, after taking orders, post this matter before this court. That order you have read, no?
There is an assignment by the Honorable Chief Justice. Otherwise, they will not.
Otherwise, they will not. If you want, we can.
No. If Lordship.
You're saying that because of the time taken in twisting the matter. Okay, but you should have brought Mr. Panigrahi.
The man is suffering, my lord, actually. He is not getting anything.
You said that.
The total pension amount is being credited to the account and it is.
There, Mr. Mishra, because pension account is different maintained by the accountant general. You have to instruct that don't credit the pension because there is no such order. Because it's a savings bank account.
We'll permit you to make a request to the employer to credit your. Is there any order which says your pension amount should be credited to this account only? Any court order?
No, man.
No order.
No. There is only.
They should have made that application in the REIT.
Only this account I have. I don't have any other account.
You could have. You can open any account anywhere.
First now. Next, right now. Learned counsel appearing for the husband on being asked, specifically submits that there is no court order directing crediting of his regularly accruing pension to the joint account in question. First, he pleads great financial difficulty of his client in these costly days because of non-operationing of the joint account. First one. If that be so, it is open to the petitioner husband in WPC to seek crediting of his pension amount to some other bank account, which he may open normatively. Your job is done. But for that amount which is remaining, we have to hear that matter.
Item 8.
And your fees also.
My lord. In the last occasion,
the argument of great difficulty related to that.
Item 8. My lord, in the last occasion, your lordship has directed the State Council to take instruction from the opposite parties regarding complaints of the order dated 10/7.
I have not received any instruction.
Have you sent any letter to them?
I also don't know, that file has not come.
You give one copy.
Give me a copy so that
he will do something on the next date of Mr. G, tell your officers. We are inclined to put somebody behind the bars, I tell you.
Yes.
Not only because of this, we have been seeing number of orders which have remained uncomplied. That will not augur well to the welfare state.
My lord, I'm conscious, my lord. I will say that the after dismissal of the appeal.
Notice is issued now.
Already.
Mr. G appears for
the contemners.
OPs there. Till now, we can't call them contemporary till charge is framed.
Yes.
1 to 1 4.
Appears 1 4.
1 2 3 4.
1 2 3 4.
All OPs.
All OPs.
And assures that he would confer with his clients and come back on the next date of hearing, hopefully reporting compliance.
Yes.
Of the order whose violation is complained of.
Particularly after dismissal of writ of appeal.
More particularly because of dismissal of the writ of appeal. First, on the next date of hearing, non-compliance of the order would be viewed very seriously and with great implications. Okay. This matter on the date when the bench next functions.
My lord,
special bench next one.
My lord, I may be pardoned, my lords.
Yes, sir. Pardon.
My lords, in item 7, Mr. Panigrai's father had been medically, due to an emergency, has been admitted to medical. He has requested me just to record his presence. My sincere apologies, my lords. Due to some medical emergency, Mr. Panigrai is not here, my lords.
So you
should have said, nah?
You should have present Mr. Sharma.
My lords, I just joined in on the request of Mr. Panigrai because he was to appear in this matter. He has requested me just to inform that due to some medical emergency,
You are saying and not listening us. You did not join when you were required to join during proceeding. Because your power is, you are Shubham Sharma, S. Sharma, along with
My lords, my difficulty is that I am out of the state, my lords. Currently, Mr. Panigrahi requested me to just to appear and to inform the court that there is some medical emergency for which he was not being able to be before your lordship, my lords.
Anyway, we have understood. Now you have to, on the next date of hearing, you have to, for wife also. We have requested you to appear for wife. Okay?
Please check now. Shubham Sharma.
That absence will be.
My sincere apologies, my lords, once again.